Welcome to New Jersey Patriot News, your source for Second Amendment news in New Jersey and around the nation. I'm your host, Matthew Platkin. Today is Sunday, March 17th, 2024. Lawmakers in South Carolina earlier this month came to an agreement on their state's constitutional carry bill and was signed into law on March 7th by Governor McMaster. The law, which took effect immediately upon the governor's signature, officially makes South Carolina the 29th state to pass constitutional carry. The bill wasn't without its pitfalls, Second Amendment advocates warn, as it included several provisions contrary to the spirit of true constitutional carry. Some examples include higher fines and possible jail time for infractions while carrying without a permit versus with, a requirement to report lost or stolen firearms within 10 days of discovery or face penalty, and the inclusion of additional so-called sensitive places, such as doctors' offices and hospitals, and churches or other houses of worship without the express consent of leadership. The law also removed the duty to inform requirement to disclose if one is carrying upon contact with a law officer, lowered the age to carry from 21 to 18 years of age, and establishes possession of a firearm alone is not a reason to stop an individual. A motion for summary judgment was filed in the case Lane v. Roca on March 15th in the Federal Southern District of New York. The Firearms Policy Coalition and Second Amendment Foundation supported case challenges New York's so-called assault weapons ban. The motion for summary judgment comes following the judge's denial of the state's motion to stay pending the outcome of the Second Circuit case National Association for Gun Rights v. Lamont, which challenges Connecticut's similar ban. The case and motion echoes similar challenges around the country in non-permissive states, including New Jersey, where a decision on summary judgment is still pending in the combined assault weapon and magazine ban cases in district court. In a related matter, oral arguments were heard in the Third Circuit Court of Appeals on March 11th in the case Delaware State Sportsmen's Association versus Delaware Department of Public Safety and Homeland Security. The combined Firearms Policy Coalition and Second Amendment Foundation supported case challenges Delaware's assault weapons and magazines ban. Second Amendment attorneys for the plaintiffs, John Ohlendorf and Aaron Murphy, focused arguments on the Bruin, Heller, McDonald, and Caetano decisions mandate that any law that implicates the Second Amendment must be based on the text, history, and tradition of firearms regulation from the founding era. Arms in common use may not be banned, and that the government bears the burden of proof that an arm is not in common use and is both dangerous and unusual. Attorneys for the state, as well as the amici, focused their arguments on interest balancing for public welfare, despite Bruin expressly forbidding interest balancing arguments, as well as making the assertion that only arms commonly used for self-defense are covered by the Second Amendment, and that so-called assault weapons and large-capacity magazines are not well-suited nor commonly used for self-defense. New Jersey Attorney General Matt Platkin announced the release of data regarding the issuance of permits to carry on March 14th. The dashboard provides anonymized data that was ordered to be collected in a directive issued in June of 2023. The data goes back to December 1st of 2019 and shows that only about 1,600 applications were submitted prior to the Bruin decision and around 35,000 were submitted after. The press release dramatizes the concern of the state, claiming that the surge in permits obtained by background-checked and qualified law-abiding citizens somehow makes residents of the state less safe and encourages individuals, businesses, and organizations to download or request signage from the Office of the Attorney General to declare their locations gun-free zones. The release and signage was immediately met with counter-arguments from Second Amendment supporters and organizations, stating that the data actually proves the opposite of the state arguments, including for the state's argued need for additional sensitive places created in their Bruin response bill, as the majority of permits were issued during the time either before its enactment or during the injunction issued by the Federal District Court prior to the Third Circuit stay. This is New Jersey Patriot News, your source for Second Amendment news in New Jersey and around the nation. I'm Matthew Platkin. Thanks for listening.